Hi, it's Connecticut personal injury attorney Ryan McKeen here. I'm going to talk to you today about how we got a $2.3 million jury verdict, and just going to walk through some general things that we did, and how a case comes in one way and how it ends in a verdict. So we got a call. We knew that our client was hurt. They were in a rear end car accident, and the accident was bad. It sent our client to the hospital, and it resulted in some need for some surgery. So we knew this was a very significant accident that was having an impact on our client's life. So what we did is we investigated it. We started obtaining statements. We started sending out preservation letters and understanding how this accident had happened. Well, at the same time, understanding the injuries that our clients had suffered. And we did this in several ways. We talked to our clients. We talked to the family. We talked to the doctors. We read the medical records. We also talk to experts who may be able to shed some insight in those medical records and help us understand, the severity of the injury. So we spend quite amount of time investigating the claim. We determined that our client is very severely injured. We determine that the other side is at fault, and we also know that given the severity of the injuries and the amount of insurance that was at question here was a commercial policy, that the case was unlikely to settle pre-suit for full and fair value, because cases that are of significant money almost always require litigation in our experience. Sometimes, if you have somebody who's very, very hurt, but there's not a lot of insurance, that can be settled pre suit. But when you have somebody who's very hurt and you have a lot of insurance money, litigation is usually necessary because insurance companies, they want to hold on to their money, and they don't want to pay it until trial, or right near trial, because they profit from that money. They invest it. They get returns on that money, and also in litigation, things can go their way. Maybe a deposition cuts in their favor. Maybe some evidence comes out that we didn't know about, that's useful to them. So they just don't roll over, and they and play and pay these claims. So we started the litigation process by filing a lawsuit. Our firm worked diligently, taking numerous depositions. Depositions are just when we, as lawyers, get to sit across from a witness, whether it be a defendant or somebody who saw the accident or a doctor or an expert, and get their opinions and understand what their testimony is, and get them to commit to that in the event of trial. So we did a whole host of depositions in this case because we needed to prove our claim. We needed to document our claim. We also worked with experts who were able to document some of the damages, like the need for future care, or the need, the lost wages that our client was going to suffer, and how to quantify those, because you can't just put that before a jury without having a basis to do it. So it takes sort of years of work, working with people in both, who are fact witnesses, expert witnesses, and trying to develop the case to document our client's story, because you just can't go into a courtroom in trial and just say whatever it is you want. You have to have evidence, you have to have proof, and that proof has to be admissible in a court of law. So you're held to a high standard, and we knew that. And so, you know what? We pushed our case, we pushed it through to trial. The pre-suit offers or the offers that came to us during the lawsuit were too low. And we knew they were too low because we had documented everything that we needed to document. We talked to the family, we talked to the experts, but we also used focus groups where we talked to people in the community, and we said, what do you think about this? What do you think about that? And the focus groups told us that the case was worth more than what the insurance company was offering. We made a whole host of demands on them. We tried to get the insurance company to do the right thing. They didn't do the right thing. And so we took them to trial. We gave an opening statement where we outlined our case, and we told the jury exactly why we were there, what we had done, what we were going to prove, and really what they were going to see at trial. And then we had several days of testimony where the jury heard from our client. They heard from the family, they heard from some doctors, they heard from some experts, they heard from the defendant. And then ultimately, we made a closing argument where we asked the jury for money. And the defense obviously said that they weren't responsible, or they didn't cause the injuries, or they didn't cause them. Um, they didn't cause us, that our client wasn't as injured, or the accident didn't happen the way that we said it did. But the jury saw the truth because we had done our work, we had proven it to them. We had met our standard in a civil case, which is a preponderance standard. And the jury came back and they awarded a $2.3 million verdict. They also found recklessness, common law recklessness, which will likely bump the verdict amount. Not That's sort of a separate conversation a little bit, but they found common law recklessness, that we had proven that, which we were confident that we were going to be able to prove from our focus groups. So, to get that kind of result, it's you have to be willing and know how to try the case, because otherwise our client would have only been offered, a fraction, maybe 10%, 20%, maybe 30% of what the jury ultimately awarded, because there's only two numbers that matter in any case, which is what the insurance company is going to offer you, or what a jury is going to give you. And so great trial lawyers like we have, Andrew Garza, Alexa Mahoney, they were able to lead this process and really get the result, because what the insurance company was offering was not what we thought what the jury was going to give, and was not full and fair justice. So if you're out there and you've made it this far in the video, good. But I really encourage you to, as you're looking to hire firms who are willing and prepared to try cases, because it's the only leverage that you, as somebody who's injured, have against the insurance company making low offers. If you want us to review your case, we're happy to do it. Give me a call, 860-471-8333 or 877 CTF wins.